Good evening, everyone. Thank you very much for being here, particularly on such an ugly night, and not so many other things that are going on, but we're thrilled that you're here with us for some very, very special people that will be sharing some thoughts that we hope you will enjoy hearing, and that you will appreciate what the IRL is all about, which is promoting civil dialogue. I happened to run across a quote this week that made me think about why we do what we do with the William T. Robinson III Institute for Religious Liberty. It was from Abraham Lincoln, who said, "The world has never had a good definition of the word liberty. And the American people just now, and that's now in Lincoln's time, are much in want of one. We all declare for liberty, but in using the word, we do not all mean the same thing." The author of the article who shared that quote said, "Lincoln's achievement and words ring just as true today as they did in the 1800s. Indeed, as we all know, probably more than any other time, certainly in my memory, people seem to mean different things when discussing notions of freedom and liberty. And part of why we do what we do is so that we can, in particular, focus on the importance, first of all, of the First Amendment, and secondly, of promoting civil dialogue." So with that, I invite Monsignor Trudell to open the evening with a prayer.
Let us pray. O God, creator of all, you give us life and plant within us a longing to know you. You reveal your beauty in all the beauty of the universe, and every creature in turn proclaims your glory. You draw us toward your goodness, and you arouse a hunger within us to respond fittingly to the wonder in our hearts, to deepen our knowledge of you, our source and pattern, to find words to express our awe at all we receive from you. As we strive to discover how best we might show our reverence, we acknowledge our frailty and failures to respect one another's efforts as we ought. Grant that we may learn ever more fully to value and support one another's right to live our faith in freedom, peace, and tranquility, so that our voices may join together in one great symphony as we proclaim, "To you be all honor and glory forever." Amen.
Amen.
Our President, Joseph Chillo, will provide opening remarks, and then followed by Dr. Robert Stern, who will serve as moderator for the evening.
I can take a shortcut. Well, thank you, Ray. And certainly on behalf of our faculty, staff, students, and alumni, and our Board of Trustees, welcome to Thomas More University. We are very fortunate to have the William T. Robinson Institute here at Thomas More to provide us an opportunity to engage in civil dialogue and the important work that we do. It's also a great fortune to have Joan Robinson here, the wife of Bill Robinson, who's on our Board of Trustees and certainly has been engaged in this work since the very beginning. At Thomas More University, we believe strongly in our mission and the values of a Catholic institution. We understand today in our society that's more needed than any other time in our history. It's also great work that's being done by our faculty to engage our students in relevant work today in understanding the responsibility that we all have to improve the communities that surround us. This evening's event, titled In Defense of Strictly Scrutinizing Religious Rights, is timely and relevant given our political, cultural, and judicial affairs today. I'd like to extend a warm welcome to our distinguished speakers, Stephanie Barclay, and our guest commentators, Lesan, I saw Holly earlier, there we go, and Gary Greenberg. Welcome to Thomas More, and we're delighted and eager to hear our conversation shortly. The William T. Robinson III Institute for Religious Liberty plays a significant role at Thomas More by creating intentional space for civil dialogue to take place to further advance religious freedom. Established in 2015, the mission of the Institute is to advance the American concept of religious freedom as an unalienable right and the protection of this right for all people, which is essential to our democratic values. Since 2015, the Institute has sought to bring dynamic and distinguished scholars to campus to engage in conversations through civil dialogue that is both timely and relevant. The William T. Robinson III Institute for Religious Liberty exemplifies the very best of a liberal arts education and the importance of understanding the differences that make up our world and communities. And these differences, as we look around society today, should unite us rather than divide us. And the pursuit of truth is an enduring quality of the values that we hold dear as a democratic society. At the forefront of the institution's work and vision is Dr. Ray Abear and the executive committee. We have a couple of those members here today. I'd like to have those stand up. Gary, I know is here. Ray here. Thank you. Yeah, I kind of showed you here. Thank you. And I have to admit that one of the most fun things in my job is to engage with these leaders. The vision, the intellect that these people bring to the conversation that we're having today is just wonderful. So thank you for the work that you do. I also like to recognize Sister Margaret Stolwater, who was the former president here at Thomas More and who's joining us tonight. Thank you, Sister Margaret, for all that you've done. Inspired by the Catholic intellectual tradition and by our patron, St. Thomas More, we challenge students of all faiths to examine the ultimate meaning of life, their place in the world, and their responsibility to others. With the William T. Robinson Institute for Religious Liberty, we can effectively demonstrate the ultimate meaning of life, our place in the world, and our responsibility to others is alive and well as the university embarks upon its second century. This evening's event brings together distinguished panelists to embody the values and the significance of religious freedom. The strength of a Thomas More education and our commitment as a Catholic liberal arts institution is evident this evening, and I thank our distinguished guests in sharing their work, their experience, and certainly their passion with all of us. I hope you enjoy this evening's presentation and conversation, and again, please extend a warm welcome to our guests and welcome to Thomas More University.
Good evening, I'm Dr. Robert Stern. I am the moderator for this evening's talk, and my very minimal responsibilities include introducing the guest speaker and the panelists tonight. First, we are delighted to have Professor Stephanie Barclay. Professor Barclay's research focuses on the role of our different democratic institutions and what they play in protecting minority rights, particularly at the intersection of free speech and religious exercise. Barclay's academic writing has been published or is forthcoming in publications such as Harvard Law Review, the Washington University Law Review, the Notre Dame Law Review, the Boston College Law Review, I assume probably a lot of other law reviews. Professor Barclay directs Notre Dame's Law School's Religious Liberty Initiative, which promotes freedom of religion or belief for all people through advocacy, student formation, and scholarship. Our first guest speaker is Holly Lesan. Lesan works for the International Center for Law and Religion Studies at Brigham Young University Law School and co-directs the center's Young Scholars Fellowship on Religion and the Rule of Law, which is held annually at Oxford University. Secondly, we have Gary Greenberg. Gary Greenberg is retired as a principal in the Cincinnati Law Office of Jackson and Lewis after more than 40 years of experience counseling and representing employers in a wide variety of workplace legal issues, including representation of religious employers and employment law matters. And with that, if we could once again welcome our guest speaker and panelists. I hope you enjoy this evening. Yes, and I don't think there is a secret.
Put one up there.
Well, thank you so much to Ray and to Joe for that very kind introduction from Robert, and to Thomas More University for hosting me. Such a privilege to be here with you all. I'm also grateful for my family. They might be the youngest members of the audience in the room, but they're the ones sitting on the front row, so very fun to have them. I was kindly taken to dinner by my hosts before coming here. My fortune says that today is a big day, and I agree. What a special treat to be here with you all. So for my remarks tonight, I hope you'll forgive me. I'm a law professor, and law professors engage in Socratic dialogue, question and discussion with their students. Old habits die hard. So I'm going to ask the audience some questions, and if you all just want to raise your hand and shout out answers so that this can be a little bit more participatory, that's how I'm hoping things will go tonight. I want to start by thinking about with you, why is it, as a society, we would prioritize protecting religious liberty? What are some of the reasons why we think government, constitution, and the different structures we have in society, why protect that value? Yes, in the back.
Because England, like the basis of why we left England was because we weren't protecting, England wasn't protecting our religious freedom. So the main reason why we left the country in the first place was to get religious freedom.
Excellent. So we have a budding historian in the room who reminds us that a really important part of our country's founding was to escape the religious persecution the different pilgrims were facing in England, where you might be banned from political office if you weren't part of the established church. You might be fined or put in jail if you weren't willing to participate in some of the religious worship services, where the established church was given funds and specific political privileges that other groups were denied. Those were things that caused some contemplation about how we could do better in this country. And that's not to say we've always gotten it perfectly, but those were certainly some of the issues that we were grappling with. We have a hand over here.
The founder said you couldn't keep a democratic constitution without good religious people.
Yeah, excellent. So religion teaches civic virtue. Religion might be instrumentally good for how people become when they're religious. And outside of just civic virtue, there's a study in a book called American Grace that studied all the different types of religion in our country. And that book found that regardless of religious denomination, when people are more religious, they contribute more not just to their religious communities, but they contribute more financially and service of their own time in their communities. As their religiosity goes up, there's a direct correlation. So we like some of the things that happen when people are religious. Yes, there's another hand over here.
I was going to say that religion is where most people's core beliefs come from.
Excellent. So part of the reason we want to protect religion is because it's core to what it means to be human. It's part of our dignity. It allows us the space. When we protect freedom of conscience, religious liberty, we give people the freedom to pursue truth, wherever that takes them, whether that takes them to organized religion or no religion at all. But it is what it means core to their humanity to be able to pursue that. Excellent comment. Yes?
I see one of the reasons why it's important is because if we strengthen it or protect religious liberty, we're actually strengthening other liberties, such as the freedom to speech, assembly, these others. So it's a bit of a catalyst for strengthening a broad range of values and rights.
Excellent. So this gentleman was saying, when we protect religious liberty, we're often protecting other rights. And one way that some scholars talk about this, the way that I thought about this, is that religious freedom rights often act as the canary in the mine shaft. And for those who don't know what that sort of analogy is about, miners used to take canaries with them into the mine shaft so that when the oxygen levels might drop too low and the canary started to fade, they noticed that before the rest of the miners would be affected if the oxygen levels weren't like they should be in some of those mine shafts. And similarly, when government is intruding too much on all kinds of freedoms, not just religious freedom, that is, this gentleman said, our freedom of speech, other fundamental rights, sometimes religious folks are the first ones to notice and to speak up because they guard those rights jealously, and also those rights often affect their day-to-day lives in really important ways. And so that can act as an alarm bell for us in society to notify us that government is intruding more than it should, period, and we might want to be more cautious about that. Something else that I think is relevant to our history that we learned early on, again relevant to this bright young woman's comments in the back, we learned that when we protect religious liberty, we have more peace as a community, and when we don't protect religious liberty, we have more conflict. I'll talk in just a minute about an example from our history, but we see that today. There are studies that show that countries that protect religious liberty have less conflict. They have more prosperity, they flourish more as a society. And at our own founding history, we early on were not as protective as we realized we needed to be for Quakers who didn't want to be part of the military. We were conscripting them into military service, and Quakers, a key religious belief of theirs is that they are pacifists. They have religious objections to fighting. And so when we conscripted them into the military and they weren't fighting, sometimes we would throw Quaker people in jail or even engage in worse penalties. And we learned that even as those penalties went up, our military wasn't getting a lot better. So we weren't like making our military more effective, and yet we were increasing human suffering. So protecting religious liberty can lead to peace and decrease needless human suffering. And what we decided to do very early on in our country's history was allow Quakers to serve in other ways and provide accommodations so that we could say these are still valuable, important members of our community, and even if they don't see it the same way we do, we can offer protection. We can decrease that human suffering. You guys touched on basically all the points I had on my list of why we protect religious freedom. So you're basically giving my speech for me. Thank you very much. One more here in the back.
Religious liberty, the founders recognized was not something that the government granted. They recognized that more freedoms were intrinsically available. And so it wasn't that they decided to protect the faith side. They recognized that it was there, pre-existing.
Excellent point. So our founders knew that religious freedom was a pre-existing right, a natural right, as some people refer to it. There was a letter by President Washington writing to a Jewish congregation. And he spoke about this freedom of religion, referring to it in a way that it pre-existed government. And we didn't have a First Amendment yet at that time. And he's writing a letter about this right that is inalienable to all human beings. Now I want to shift gears a little bit. And in the first case that was interpreting the religious exercise clause in our First Amendment, that didn't come about until the 1840s because our Bill of Rights, our federal Bill of Rights, had been interpreted as only acting as a limitation on federal government, not state and local governments. That expansion didn't come until later in the 1900s when we interpreted the 14th Amendment. And then at that point, free exercise protections limited all government. But so go back with me, if you will, to that point in the 1800s when we're dealing with a federal territory in Utah, and so that's why the federal government is now involved. And the government, in this case, was prohibiting polygamy. And so there was a challenge brought about whether the free exercise clause should protect that. And in that case, the litigants asked for a jury instruction that said that as long as someone's religious belief had sincerely motivated their conduct, that government shouldn't be able to criminalize them, period. Now, if that jury instruction was accepted as the guiding legal standard, are there any concerns anyone can think of if that's the rule? As long as you have a sincere religious belief, government can't criminalize your conduct. Yes?
It can be used, and has been used by cult-like members to dehumanize other people and to have their own constraints on their sort of group.
Yeah, so we might be worried about how religion might be used to hurt other people. You mentioned cults. Of course, one of the hypotheticals that law professors love to talk about is, what if the Aztecs gained popularity and human sacrifice was popular again? But on an example closer to home, I was speaking about this with some students earlier today, but there is a case not too long ago that came out of Indiana where a mother was claiming the religious freedom right to beat her child with a hanger or other metal instruments. And she said, I read the Bible and it tells me spare the rod, spoil the child, and so my religious liberty rights should protect my ability to beat my child with metal instruments. She didn't win that case. But what I'm highlighting is that there has been this tension that has been with our country for a long time, and that is, how do we protect religious freedom, gain these values that are so important that we just started this discussion with, and not give too much protection? How do we not allow religious people to have a blank check to get out of law free card in a way that might sometimes be harmful for other third parties? So that's a question that our Supreme Court is still grappling with as it thinks about what tests should we implement to protect religious exercise. And I'm going to talk about some of the cases that have been relevant in that area. But first, I want you to think with me about a real religious freedom case that has arisen as we sort of think about what should we do, what sort of tests should we use to provide protection in this sort of context. There is a stretch of highway in Oregon, and on one side of the highway was a Native American sacred site that was a historic burial ground and also a place of active Native American ceremonies. But the government wanted to expand this stretch of highway because there had been some car accidents, and the government was pointing out that if there was a wider highway with a turn lane, their evidence indicated that that would allow them to decrease car accidents. So how do we reconcile this sort of a conflict? There are a couple different options. We could just say, well, we'll just defer to the political process. Maybe political actors they know best how we ought to protect religious freedom. And so the interested Native American plaintiffs in that case can comment and participate in the notice and comment procedure of the government agencies that are considering the highway widening. And then we just leave it to that. Maybe courts shouldn't have a say. Another option is maybe courts should somehow be engaged in balancing the relative value of these two interests. Can they balance the weight of the need to protect lives and prevent car accidents on one hand, and the importance of this Native American sacred site on the other hand? Or maybe what we could do is, if we take an originalist, historical analog sort of approach, we could look at, are there examples of the government regulating in this way in the past? And if so, then the government wins, and if not, then maybe the religious people win. These are some of the different options we might think about, and that scholars in the Supreme Court is actively thinking about. So I'm going to come back to this example in a moment, but first let me walk you through some of the cases that we've had in our country's history that have arrived at different answers to these questions. So if we go back in time to the 1940s, when at this point the First Amendment has been interpreted to apply to all government officials, not just the federal government. And if you imagine in the 1940s, we're a nation on the brink of war, World War II. There's a lot of concern about ensuring that we have sufficient patriotism, national unity, and that we, as a nation, are able to sort of rally together during this difficult time. But also, at this time, there's something else going on in Germany, and that is that Jehovah's Witnesses are one of the only groups that is being sent to concentration camps for a reason that is entirely in their control. And that is that they refuse to perform the Hitler Nazi salute, where they raise their hand like this, obviously, and engage in that sort of Nazi salute. They viewed that as idolatrous. They refused to perform that salute, and as a result were being sent to concentration camps. In the United States, we don't do this anymore, but at the time, our salute during the Pledge of Allegiance, our flag salute, looked like this. And so there was a radio address by a Jehovah's Witness leader that talked about how, as a show of solidarity for the German brother and sister Jehovah's Witnesses that were not performing this salute, this Jehovah's Witness leader similarly encouraged American Jehovah's Witnesses not to perform the flag salute, the Pledge of Allegiance flag salute, and also raised concerns about whether or not that was idolatrous. So there was a young boy named William Govitis, 11 years old, who heard this address and was moved by it and thought, I'm not going to salute the flag the next day in school. I'm going to make sure that I sort of follow through with that encouragement and stand with my other Jehovah's Witness brothers and sisters in Germany. So when the time came to salute the flag, he kept his hand down. His teacher actually tried to physically lift his hand up. He was able to keep it in his pocket. And as a result, he was expelled from school. His family-owned grocery store was boycotted and threatened with mob violence. And then after this case happened, or after this incident happened, there was a lawsuit that made its way to the Supreme Court, raising the question of what sort of protections does the First Amendment provide in this context. And the Supreme Court said, our job is just to defer to the political process. We have to defer to those who are in office, and it's not our job to interfere. The need for national patriotism and unity is more important than providing immunity for dissidents, and so no protection for William Govitis. After that, some scholars have written about how it was as though the Supreme Court had declared open season on Jehovah's Witnesses. There are FBI recorded accounts of Jehovah's Witness churches being burned to the ground, a Jehovah's Witness person being force-fed castor oil and frog marched through the streets, even some fatal instances with members of the Jehovah's Witness community. Just a few years later, the Supreme Court took a very similar case and reversed its position. And this is a case called Barnett. And the Supreme Court said, we got it wrong. That was the wrong approach. In fact, the very purpose of the First Amendment and of the Bill of Rights is to say that there are some protections that ought to be removed from whatever the popular preferences are of the majority. And if there's any fixed star in our constitutional system, it's the fact that no government official, high or petty, should be able to dictate what is orthodox. So that was the rule for some time. That came out in the 1940s. In the 1960s, the court formalized a test called the strict scrutiny, where the court said unless government demonstrates that it has a compelling interest, a very strong interest, for interfering with religious exercise, and unless it shows that its actions are narrowly tailored to that interest, then the government can't interfere. That's the way that we're both going to provide a safety valve for government. We're not saying that as long as someone's religion is sincere, they get to do whatever we want. There will be important cases where government can limit that. But we're saying that the government really has to demonstrate that it is important. So that's how it worked for quite some time. We had a case in 1972 called Wisconsin versus Yoder. This was a case dealing with whether the Amish should be required to send their children to public school. Can anyone guess what the government's justifications were in that case for why it should be able to force the Amish to send their children to public school? Jonathan?
Is negligence to not?
Say it again.
Negligence to not send them there?
Negligence to not, it might not be helpful for those children to learn things that they need to learn. That was an argument made. Anyone think of anything else? If you're representing the government, why would you say we need to allow the government to force people to send their kids to school? Yes.
You could argue everyone has a right to an education, that parents can't withhold that right from children.
Good. That was an argument that was made. Very good. Yes.
Oftentimes, when children are more educated, they pursue higher education like we are, therefore it stimulates the economy further, which benefits the government as well.
Good. So these comments were about children have a right to an education, and also if these children receive an education, they'll be able to be more valuable contributing members to society. These were all arguments that the government made in their briefs. One more over here.
The government also did that with Kansas
Say it again.
The government also did that with Catholic missionaries in the West, and I believe those laws were just rescinded not too long ago, where they prohibited Catholic missionaries from establishing schools so that the government schools could, take over the education of the children. I forget the name of that. The name after a man, Bain or Blaine.
No, Blaine amendments, yeah. Yeah, that is another interesting dispute that's going on in the context of education. Maybe we can talk about that more too in the Q&A. That's a really interesting area. So in this context of public schools and the Amish, you all would have made excellent attorneys for the government. Those are exactly the types of arguments they made. But I'm going to put on a more cynical hat for a minute and tell you another reason that came out in litigation. And before the government cracked down on requiring the Amish to send their children to school, the government approached the Amish and said, would you be willing to send your kids to school at least for the first 2 weeks? Because in the first 2 weeks, they do sort of like a census count and audit, how many kids come, that affects how much money we get, and then you can send them. Like, we don't really care after that first 2 weeks. And the Amish were like, yeah, we're not looking about that. We're going to just like not send our kids to school. And then suddenly the government got real interested in rights of children and contribution to society and economics and things like that. Now, that's not to say the government never has real interest and that those arguments aren't fair, but it's also a reason why sometimes we might be skeptical of arguments that the government makes in some of these cases. And the Supreme Court found in that case that there were already a lot of ways in which the Amish community was contributing to society, that they were upstanding citizens, they had a lot of industry, there was low crime rates, there were alternative education opportunities that the Amish were providing. But one thing that the court also did in this case is it said that it was balancing the value of religious liberty protections for the Amish against the government's arguments about rights for children and contribution to society. And Justice Scalia, fairly, I think, had some concerns about this sort of conceptual framework where we're balancing the value of religion on the one hand and the value of rights of children or contribution to society on the other hand. And he didn't like balancing anywhere, not just in the religious context. But he said, he once put, that's like trying to compare whether the length of this string is more than the weight of this rock. They just don't translate. We're dealing with different criteria, they are incommensurable. It's an inherently irrational thing for judges to do. So I think in part based on those concerns, along with other concerns, in 1990, in a case called Employment Division versus Smith, when a Native American was seeking a religious accommodation to use peyote as part of a religious sacrament and be able to receive an unemployment accommodation as a result, the Supreme Court, sua sponte, which means on their own, without any party asking them to, overruled this prior framework where we use strict scrutiny and said that we're going to go back to the test from Gobitis, and we're just going to say if government has not acted in an overtly discriminatory manner, then we'll defer to government. Courts shouldn't really have a role in saying what religious rights should be because we don't want courts involved in this process of balancing. Congress responded just 3 years later nearly unanimously and passed the Religious Freedom Restoration Act. And my argument tonight is that this version of strict scrutiny that Congress passed, I think, is a type of strict scrutiny that avoids that concern about balancing and still provides robust protection for religious liberty, but not a blank check. It still offers government opportunities to achieve its important goals. And the way that strict scrutiny works under this framework is government still has to identify an important interest, but we don't balance that interest against the religious interest. We just then ask an evidentiary question, has the government really demonstrated that its actions are necessary to advance that interest? So, in a way, this operates as what legal philosophers call an exclusionary rule. Joseph Raz talked about exclusionary rules. If you think about, if you imagine the scale of justice, there are some things that just don't get to go on the scale. So if I'm a professor grading students' grades, the fact that the students analyzed it well or had good organization, those might be things that go on the scale. But the fact that the student wore shoes that were a style I really disliked, I just don't put that on the scale. Even if I really dislike them, it just doesn't go. I just don't consider that interest. And so the way that it works under this test for strict scrutiny is that unless the government is putting a really important interest on the scale, like public safety, national security, health, other sorts of welfares related to the public interest, unless one of those goes on the scale, something like mere inconvenience or some marginal cost, we just don't consider those. And so the government's job is to demonstrate that its actions are necessary to advance one of those interests. That was all a little bit abstract. So what does that mean in more concrete terms? Let's return to the Native American example that I started with. So instead of balancing or instead of totally deferring to government officials or freezing laws in place and not looking at them again based on what government can or can't do, this alternative approach under strict scrutiny first looks at what is the government's interest. There the government claims we have to reduce car accidents, we need to increase public safety. And so if we're just then asking the evidentiary question, well, is widening the highway in this way, where you bulldoze a Native American sacred site and cut down their old trees that act like the walls of the church to them, is that necessary to result in public safety? And in that case, the claimants ask the government, you know, there's another side of the street. Have you thought about bulldozing that direction? The government had no good answers for that question, and later admitted, the government did end up bulldozing the Native American sacred site, and later admitted, and at the appeal, that that destruction was unnecessary. In other words, the government could have both widened the highway to protect against car accidents and protected this Native American sacred site. And the work that strict scrutiny, I think, is meant to do, when done properly, not done in a balancing way, is to hold the government's feet to the fire, to make sure that that really is what the government's doing and that it hasn't considered other alternatives. Often in the media, we portray religious liberty as being in irreconcilable conflict with some of these other important goods, like public safety. But what strict scrutiny does is require government to think harder about, is there a way that we can accomplish what we want to do and protect religious people too, so that we can have all those values we talked about in the beginning. More peace, more human flourishing and dignity, less conflict, less needless suffering. It is what economists refer to as a Pareto efficient improvement, where one party is made better off in a way that doesn't hurt the other party, and that we should seek for more of those outcomes as a society. And in fact, that's the way that in our very earliest reported religious accommodation case in 1813, those are the types of questions that the court asked coming out of the state of New York, a case called People versus Phillips. Their Catholic priest had been subpoenaed to testify about a burglary that he had received a confession about from the burglar who took a necklace. And the government was trying to force him to testify. And the government was claiming, we have to do this in order to decrease crime. And the Supreme Court there asked the same sorts of questions that we ask now under modern strict scrutiny. It said, have you actually demonstrated that if you force this Catholic priest to testify about the confessional, that crime will be decreased? Because we're skeptical. We think if that's the rule, then all future criminals will just know, well, we can't confess anymore. And the Supreme Court said, and that might actually lead to people committing more crime if they can't repent and become better people. I don't think we would see a court say that in today's day and age. But the court also pointed out that the government allowed protections for testimonial privileges in other contexts, and it wasn't being even-handed by failing to protect religious liberty there. So the test that Congress has put its stamp of approval on and that we used at the founding of our nation, I think, is one that can avoid some of those other pitfalls and still provide a way for us to navigate allowing government to do its work and still giving as much protection as we can for this important, enduring value of religious liberty. And with that, I'll pause there.
Well, this is really fun. I've had a good time over the last few weeks reading what Stephanie's written on strict scrutiny, and it's one of my favorite traditional doctrines, and it's fun to get to be here with you and talk tonight. Stephanie and I know each other a little bit. We mostly see each other in the United Kingdom, as it turns out. This is the first time, even though she lives in the Midwest and I live in the Midwest, that we've seen each other in the Midwest or even in the United States. I've had the pleasure of attending a few events hosted by Stephanie at Notre Dame Law School's London Center. And this summer in Oxford, England, not Ohio, we actually were at a conference together that was co-sponsored by Notre Dame and by the International Center for Law and Religion Studies, where I work at Brigham Young University Law School. And that conference was called Civilizational Perspectives on Human Dignity. And so as I respond to Stephanie and talk about more what she's introduced, I want to talk a little bit about human dignity and give you some background there. This idea comes from a document called the Universal Declaration of Human Rights, and 2023 is the 75th anniversary of this wonderful document. If you think back to 1948, the beginning of the United Nations, the world was coming out of World War II, and we want to make sure that the atrocities suffered by the Jews and by others never happen again, that the Holocaust never happens again. And as part of that, we want a Universal Declaration of Human Rights. And so a committee is assembled to draft this document, and it's a committee, an international committee with representatives from all over the world. And it gets really hard because not everyone has the same idea on what a human right is or what dignity is. The amazing thing is that eventually the document is written and it passes unanimously at the United Nations General Assembly in 1948. And we've spent the last few years at the OU Law School's International Center for Law and Religion Studies really thinking hard about human dignity and about the Universal Declaration of Human Rights and what that means and how do we promote the creation and sustaining of human dignity all over the world. So at this conference in Oxford, we heard from a wide swath of international professors, academics, government ministers, members of parliament, UN Special Rapporteur for Freedom of Religion or Belief, and a wide variety of people, and also our very own Stephanie spoke to us at that conference. And our primary goal there was to build momentum for a UN Human Dignity Day. And there are lots of days on the United Nations calendar, and some of them seem to overlap. There's a Human Rights Day, there's a Religious Freedom Day, which by the way is next week, October 27th. We can celebrate Religious Freedom Day. There's also an International Day of Tolerance, International Day of Commemoration and Memory of the Victims of the Holocaust, and others. But we really felt like Human Dignity Day offers something a little bit different and complementary to these other really important observances. And that's because human dignity is a little more fundamental, it seems, even than human rights. And it gets at this idea that Stephanie was talking about in not just having a general neutral law that's applicable to everyone and if it doesn't work for you, oh well, but really thinking hard about how we can watch out for each other. And I think that's what human dignity does. We have an international colleague whose name is Jan Fiegel. Jan was the European Union's first special envoy for the promotion of freedom of religion or belief outside the EU. I have to read that so I make sure I get his title right. That was his job, and he often recounts an experience he had when he was trying to talk to various countries about human rights issues. And he picked up the phone one day and was talking to a country that he felt like had some particular human rights abuses, and he knew it was going to be a hard conversation. He said, "I'd like to come and talk." And he felt sort of a chill in the conversation, a wall go up, and this government minister said, "About what?" And he said, "Actually, I want to talk about human dignity." And immediately the conversation changed, and this official said, "Oh, I would really like that. Dignity is really important. In fact, in my religious tradition, in my sacred text, human dignity is a very important part, and I would love to discuss dignity with you." And I think that has held true in various places. Sometimes when we talk about rights, well, these are my rights, these are your rights, a wall goes up and there's a chill in the conversation. But when we talk about dignity, that invites warmth into a conversation. It invites shared experiences, and that's something we can build on. So the Universal Declaration of Human Rights reads in its first article, "All human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood." And then Article 18 reads, in part, "Everyone has the right to freedom of thought, conscience, and religion." So I want to talk about this word conscience a little bit and what that means. And in English, we think of conscience as something individual, it's internal. I'm acting in accordance with the dictates of my conscience. You feel a certain way and that's internal. But in the Universal Declaration of Human Rights drafting sessions, there was a Chinese delegate, a scholar named P.C. Chang, and he suggested that Article 1, talking about conscience, should be this concept, a Chinese concept called Ren. And I don't speak Chinese, but according to Mr. Chang, The translation for Ren is two-man-mindedness. It combines two characters, man and two, and it's a Confucian idea that implies something a little more than internal, it's external. When we're thinking about two-man-mindedness, two-person-mindedness, it's not just my conscience, it's your conscience. It's our shared experience there, and we have to look at each other and think about what that means. So if we're two-man-minded, we're thinking about something more than just our internal guide. We're looking at our fellow human beings with something like empathy, with benevolence, with compassion. And that takes a little bit more work to see each other in that way. Chang pointed out that rights, human rights, also imply duties, and that rights and duties are best understood in the context of relationships. There's a relationship that we have with each other as fellow citizens. There's also a relationship that we have as a citizen to our government. And when we can see each other as having a right and a duty to each other, that changes the conversation. And so if we're thinking about a government and a citizen viewing their relationship, viewing themselves in a relationship, and having a right and a duty to each other, and maybe if we can reach higher in empathy and compassion for each other, how does that change the conversation? Now, how are we thinking about things like strict scrutiny? How are we thinking about our religious freedom policies, our legislation, how we approach a court case? That changes the conversation. If we can think a little more like this two-man-mindedness, this human dignity that we honor internationally in the Universal Declaration of Human Rights. One of the things I think it helps us do is understand that we are all part of a minority somewhere. And when we're keeping the treatment of the other in mind and implementing and the rule of law, this can be a useful framework for a harmonious society, this concept of Ren. We're looking outward, we're trying to empathize with and honor the beliefs of those around us. So I was disappointed a couple of years ago the Supreme Court had a chance to overturn this Employment Division versus Smith case where we have this general and neutral law test that Stephanie talked about, and we thought we might get it overturned and go back to the strict scrutiny, and we didn't quite, and we may yet still. I think we're all hoping a little bit that that will happen. But I love the way that Stephanie approaches this, and not as a, we don't want to balance this, we don't want to have a strict historical analog, but we want to have this, this understanding that if we're treating everyone equally, we're missing the accommodations that are needed by minorities, and we are all minorities somewhere. We want to look a little bit to our founding, and I love that Stephanie brought up the Quakers, and the Quakers in the Revolutionary War they're pacifists, and so it would be contrary to their conscience to fight in this war or even to finance the war. And Pennsylvania, which was the home of the Quakers, was a very wealthy colony during the war and had money that needed really to be contributed, but the Quakers didn't want to do it. And as Stephanie said, penalizing the Quakers didn't make the Revolutionary Army any stronger, but it did create a lot of consternation and a lot of conflict. One of the things that George Washington did in 1789 was to write a letter to the Society of Quakers. And he wrote about this, the privilege that we have of worshiping Almighty God in a way agreeable to our conscience, and that this is not just a blessing, but also a right. And again, this is before we have any sort of First Amendment, but this is something that is a fundamental right we have, to worship according to our consciences. Washington continues with something that I think is really remarkable, and I'll read you part of this letter that he sent to the Quakers. I assure you very explicitly that in my opinion, the conscientious scruples of all men should be treated with great delicacy and tenderness, and it is my wish and desire that the laws may always be as extensively accommodated to them as a due regard to the protection and essential interests of the nation may justify and permit. This is George Washington, the president of an infant nation. The war has been very grueling, and the freedom they have is hard won, and he's turning to this religious group who, as a matter of principle, did not participate in the war either physically or financially, which caused Washington some amount of pain. That cost him something, because as the leader of the armed forces, it was his job to win the war, and he didn't have the support of the Quakers. But here he turns around and he reassures them that he wants to protect that expression of their conscience, even if it cost him something. And he doesn't do it grudgingly. He uses this expression, great delicacy and tenderness. He wants to treat their conscientious objection to fighting with great delicacy and tenderness, and he wants them extensively accommodated. He wants that accommodation to be expansive. And he wants the laws of the new nation to do that as well. It's not just him personally. Earlier in the letter, he does point out that he thinks the Quakers are exemplary citizens other than not fighting alongside him. They did a great job being exemplary citizens, but he doesn't dismiss them as disloyal, and he doesn't hold a grudge. I think at least one lesson from Washington's letter is that the views of those with whom we disagree, even though it causes us to bear what we think is an unfair burden, should be treated gently. He also wrote to the Hebrew congregation in Newport, Rhode Island a year later, and celebrating what he felt like the United States had given to the world, that he had given the world an enlarged and liberal policy worthy of imitation. All possess alike liberty of conscience and immunities of citizenship. It is now no more that toleration is spoken of, as if it was by the indulgence of one class of people that another enjoyed the exercise of their inherent natural rights. So what he's celebrating, and it's aspirational, it was aspirational for Washington, it's aspirational still for us, but not just a toleration of each other, but a liberty of conscience that is freely exercised, that we are expansive in our accommodation of each other. And I think that's really remarkable for his time period. Just tolerating each other isn't enough. Washington wants honor and he wants respect. One of the things he does in this letter to the Hebrews is quote from Micah chapter 4, everyone shall sit safely under his own vine and fig tree, and there shall be no one to make him afraid. And if you're a Hamilton musical fan, you're singing that right now in your head. I am too. It's aspirational, but I love that image. What he wants is for us, each of us, to sit safely under our own vine and fig tree and not be afraid of living who we are, of expressing our religious beliefs as we need to. It's not a grudging toleration, it's one of great delicacy and tenderness. And I think that's what we're really getting at when we talk about strict scrutiny. We're asking the government to take a hard look at what exactly is the need and how narrowly can it be achieved without treading on the conscience of someone else. When we're talking about the state making accommodations, I think we want to look at Washington's aspirations. And my favorite description of what it means to accommodate someone's religious belief, religious manifestation, comes from our Center Director and BYU Law Professor, Brett Sharfs. And he talks about accommodation in 3 different ways. And the first one is as an unfortunate exception to a general and neutral rule, right? There's a government rule and someone needs an exception to it, and the government says, all right, I guess you can have that. It's kind of begrudging, it's unfortunate, it doesn't give the person seeking that exception a feeling of great warmth or welcome, but it's accommodated, it's technically accommodated. The second meaning could be that the person has to accommodate the government's request, that a person is making an individual adaptation, a change to what might be their religious practice, their manifestation of religious belief to adjust to the needs of the state. And that doesn't work very well either, right? And so the third way we can think about accommodation and a religious accommodation is as a form of hospitality. Not an unwanted house guest, not an unfortunate intrusion in our day, but offering a place of refuge and safety to the weary traveler. And I think that's what Washington is getting at. He wants us to be welcome and safe in our religious manifestations. I think that that's what we're getting at when we're talking about strict scrutiny. We're asking to take a look where there's a limitation of a religious manifestation that has to happen, where the government does have an interest. We want to look at what is the best way to achieve that. What is the way that is most accommodating in the fullest, most expansive sense of that word to achieve that interest. And I think it goes back to human dignity and to rent, to man-mindedness. Can it accommodate 2 fellow travelers on a road with different needs, different religious needs, different state and religion needs in those relationships, and can it accommodate the innate dignity of the citizen and the necessity of the state? Thank you.
Well, I was also going to read from Washington's letter to the Jewish congregation, but I don't have to do that now. I retired from my law practice a few months ago, but during my 40-plus years of practice, I had to wrestle with these issues in the trenches in two different respects. I represented some religious employers, and so we dealt with issues involving government regulation of the employment relationship between employers and employees, and whether those regulations could apply to a religious employer, and if so, to what extent. Also, I dealt with and represented and advised secular employers who employed religious employees. And we dealt with issues of to what extent does the law or practicality require the accommodation of employees' religious beliefs and practices. So I'm going to step back for a minute here and talk about the context, the historical context in which these issues arise. In the late 18th century, there were two violent political earthquakes that still have repercussions today. There was a rebellion, of course, by the American colonists against their British overlords that resulted in the Constitution that is our governing document. And that Constitution, of course, as you know, includes a First Amendment that provides for and protects the free exercise of religious belief and practice. And it also has another provision that some say is in tension with free exercise. I say it's actually complementary, and that's the clause that says that the government shall not establish a religion. Shortly thereafter, we had another violent political earthquake in France called the French Revolution. In contrast to the American Revolution, the French Revolution was anti-religious, anti-clerical. Different contexts, different reasons. In the United States, the colonists were a variety of mostly dissenting Protestants, some Catholics, a handful of Jews, a handful of Muslims, and it was a revolution mainly by people with a variety of religious beliefs and practices. In France, in contrast, the revolutionaries viewed the Catholic Church, which was the predominant religion in France at the time, as being part of the establishment against which they wished to rebel. So the rebels, the revolutionaries, did their best essentially to destroy religion and to destroy the Catholic Church. Now, in the Statement of the Rights of Man in France, there is a statement that says that people would have freedom of conscience, a form of freedom of religion. But at least in the early days of the revolution, that was scarcely respected and honored. Eventually, things settled down in France, and the French developed a concept called laïcité, which is essentially a way of saying is that in the public sphere, the secular predominates over the religious. So in France, it's perfectly acceptable to pass a law that says that students may not wear religious garb when they come to school. And if it's a Muslim girl who wishes to wear a scarf over her head, or a Jewish boy who wishes to wear a skull cap, or a Catholic girl that wishes to wear a large cross, it's perfectly acceptable in France to prohibit that. At least that's the predominant view in France. But that's not the United States of America. That is not our founding. Again, a different concept, a different context. I contend, and I think my colleagues here agree, that in our constitutional system, religious belief and practice is privileged. as against secular belief and practice. That doesn't mean, of course, anything goes. I think it was pointed out is that we have a revival of the Aztec religion. We're not going to permit human sacrifice, even if they sincerely believe that that's what their gods want. But we have many examples, some of which have already been given to you, of where religious belief and practice has been privileged over general rules and general regulations, going all the way back to our founding. And it's my view that that is the way that the First Amendment religion clauses were understood. After all, they already included a clause that said freedom of speech. And of course, that would protect religious speech just like it protects secular speech. But the founders who insisted on this First Amendment also included a separate clause that says that we are going to protect the free exercise of religion. And yes, that we're not going to allow the federal government to establish a religion. And of course, with all the varieties of religious belief and practice, at the time, nobody wanted the government to be able to say, there's only one way to believe. We're going to establish, as in England, the Anglican Church, or the Baptist Church, or the Presbyterian Church. That's going to be the church that everybody needs to belong to, or at least that's the church that's going to have all of the privileges that the government can give. That's not what our founders intended. That's not what was understood. We were not going to establish a church, but that does not mean that our founders thought that the public square and the public sphere could be cleansed of all religious belief and practice. Now, I'm going to give you two examples of how religious belief and practice are privileged with two Supreme Court decisions from recent years. And I'm also going to show you that this concept of the privilege of religious belief and practice it can be controversial, and it can be difficult in practice to apply. So, you heard mention of a law that was passed in the 90s called the Religious Freedom Restoration Act. And this was done in response to the infamous Smith decision, where Congress virtually unanimously came together, liberals and conservatives, Democrats and Republicans, and said, we need to protect religious belief and practice. Because we have individuals out there who sincerely believe in what they're doing and how they're doing it, and we're not going to allow the government, we do not want the government to trample on the conscience and the practice of people who sincerely believe in the religious practices. And so what the Religious Freedom Restoration Act says is that in order for the government, the federal government, later the Supreme Court said that RFRA doesn't apply to state and local government action. So RFRA says to the federal government, if you have a law or regulation that interferes with sincerely held belief or practice, you, the government, must show that there is a compelling government interest, not just a good interest, a compelling government interest. And in addition to that, you're going to have to show that there isn't a less intrusive way to fulfill that same government interest. Like with the case of the road, knocking the trees down on the other side of the road, not where the Native Americans have their sacred grove. So a case made its way through the court system involving RFRA that was quite interesting. There was a group in Santa Fe that started a church, and with this church, they used as a sacrament not wine, but a substance that is derived from a plant in the Amazon jungle called ayahuasca. And when you drink ayahuasca tea, you have hallucinations. And ayahuasca is a Schedule I drug. The federal government has said this drug is so dangerous that we're going to make it illegal, and you can be severely punished for selling or distributing ayahuasca. So this church in Santa Fe is importing ayahuasca from the Amazon, and the federal government seizes it and confiscates it. You can't bring this stuff into the United States, it's illegal. And the church went to court and said, this is our sacrament, and the government does not have a compelling interest to stop us from using this sacrament. Went all the way to the Supreme Court, and the Supreme Court agreed with the church in Santa Fe. The vote was 9-0. Now, why is something like this controversial? Well, as I stand here, you know, in my religion, we drink wine on occasions, but we don't use hallucinogenic substances. But I might very well have an interest in it. So if those of us who don't have a sincere religious belief that this is a sacrament wish to consume ayahuasca the same way that these folks in Santa Fe are doing so, we're not allowed. It's illegal for me, but it is now legal for them. And so you can see that there is an argument that there's something fundamentally unfair about that. And I want to allow our featured speaker to respond and explain to you why that isn't necessarily fundamentally unfair. I think there were some comments made about the two minds, two different people down the road who have different needs, different beliefs, and I think that makes a lot of sense in a pluralistic society like ours to accommodate these differences in religious beliefs. But it is controversial and it can be difficult to explain to people in the wider world. The second issue, the second case I want to talk about involves individuals who do not wish to work on their Sabbath. And back in 1964, when Congress passed the Civil Rights Act, which finally began the process of smashing the ugliness of Jim Crow, this is a law that said race discrimination in this country is unlawful. That same law also prohibited employers from discriminating based on sex and national origin and religion. And then it was amended in '72 to clarify that employers would have to provide a certain amount of accommodation. The Supreme Court back in the early '70s ruled in a case called Hardison that if there was any burden on the employer, even a trivial burden, then that accommodation would not have to be provided to the religious employee. And again, as an employment attorney, I had to wrestle with these issues all the time. But last year, in 2023, the Supreme Court of the United States overruled Hardison and said that if an employer wants to apply its general rule and requirement that you have to work 7 days a week to a religious employee, it would have to show a very significant undue burden. So this was a case filed against the Postal Service, and there's a group of employees that have to work on Sundays, and this individual said, I can't work on Sunday. I'm an evangelical Christian. I have to go to church on Sunday. It's my day off. And he was terminated. Can't recall whether he quit or he was fired, but took the case all the way to the Supreme Court, and the Supreme Court said that under this statute, under this law, this individual has a sincere belief that he shouldn't work on Sunday. You, the post office, have to show that allowing him that day off would be a substantial burden on your operations, not just a trivial burden. And again, the point I want to make here is that, and again, I believe the law was correctly decided, but, or the decision was correct. But again, keep in mind that all of his coworkers who don't have the same religious beliefs, they don't get Sundays off. They don't get Sundays off. So exceptions are made from the general application rules and regulations based on sincerely held religious belief. I believe that this is what was intended when the First Amendment was added to our Constitution. I believe that this is also good policy because it protects individuals in a very diverse and disparate society to be able to live lives and live the lives that they believe that they should live. But please understand that these are not simple issues, that they do tend to be controversial. Sometimes you'll find that it depends what religion is being talked about, what the practice is, whose ox is being gored. But one thing that is very, very clear, this principle that religious belief and practice is protected applies to all sincerely held religious beliefs and practices in this country. The indigenous religions, Jews, Christians, Muslims, Buddhists, etc., etc. And in our diverse, pluralistic society, I think that's a good thing. Thank you.
So we have reached the Q&A section of the night, and I believe, if I understand the protocol correctly, we are going to have some students come down. If you have a question, students will pass a sheet of paper, a small note card. They're asking you to write down your question. Students will then collect said questions, and they will filter up here. In the meantime, so far as I think there was a question, Professor Barclay, if you want to speak to the fairness issue as it concerns the ayahuasca case. And if you do have questions, please just raise your hand, and we have students around that can see you and pass you a pencil and a note.
So this excellent question is one that it's still being debated pretty vigorously by scholars today, and that is, why should we give religious beliefs some sort of premier protection under the law compared to other strongly held beliefs? And so, I mean, one obvious answer, just as a matter of positive law, is that our Constitution specifically calls out religious exercise. It doesn't call out, just conscience. They thought about it. Earlier versions of the First Amendment talked about protection of conscience, which is a broader thing than just religious exercise. And they made a deliberate decision to narrow in. Now, one could ask, well, is that a good idea? Like, forget what it says. Is that a good idea to just protect religious belief as opposed to other strongly held beliefs? Because other countries, much of Europe and Latin America and some of these international instruments that Holly gave an excellent overview, protect freedom of religion or belief. So they do protect really strongly held beliefs, which would be good news for a lot of fans of Notre Dame football, because it's basically a religion for them. I have learned living in South Dakota. But here's at least a couple arguments for why I think religion might be entitled to some stronger protections under the law, or why human flourishing and decreasing of human suffering are often unique to religion. One is that this is something that Professors Doug Laycock and Chris Lund and Mark Storsley have written about. It is often true that with other sorts of rights, like freedom of speech, for example, that there might be a lot of different ways that you can accomplish what it is that you're wanting to do in order to accomplish that right or that interest. But for religious beliefs, it is often true that there's just sort of like one particular way to do something. If your religion requires you not to work on a particular day of the week, then that really matters. Whereas someone else who just wants certain days of the week off so that they can go to Notre Dame football or whatever else that it is, they might have more flexibility about when they can do different things or how they can do different things. If you have freedom of speech and the government limits your ability to speak in the park on certain days of the week, you might be able to come other days of the week. And so because there is more particularity with religious beliefs and there's a conflict with the law, the pressure is more acute. It is also true that there's some studies that talk about ways in which religious people, especially like particularly Orthodox people, they're just less likely to respond the government penalties or government regulations in the way that others would, because for them, sometimes eternal life is on the line. And so whatever the government is going to do to them in this life, that pales in comparison to whatever sort of eternal ramifications are going to be for them. And that is what we learned very early on in our country's history when we kept trying to throw the Quakers in jail. Jail paled in comparison to their eternal commitments. And so we started to learn that just putting more pressure on religious people doesn't seem to be solving the problem. The other thing about religion is that while a Notre Dame fan might have very strong views about that particular activity, it's rare that their love of Notre Dame football will pervade much of how they live their life throughout their entire life. Whereas religion, as the Supreme Court has discussed in different cases, without ever actually completely defining it, that there's a sense that religion is more comprehensive. It affects the ways in which we live our lives across a lot of domains and a lot of different areas. And so the risk of conflict is higher than if you have one isolated belief that you hold really dearly. But that said, there are countries with different views that still care about religious liberty a lot, that do protect it on an equal playing field with conscience. And so I think that it's still a fair discussion, a fair debate about which approach is better.
So the question is the following. We have discussed the importance of separating the government from individuals' religion. However, at what point must we separate religion from the government? For example, Roe v. Wade was a very religious issue while also being a large political issue. There's your softball.
So, however you feel about Roe versus Wade, I think that, or the decision to overturn Roe versus Wade, I think that people have made a mistake in criticizing the Supreme Court majority for making a decision based on their, quote, religious beliefs. You can quarrel with the decision for a lot of good reasons and some bad reasons, but we all bring our our premises to our lives, to the way in which we make decisions. And for example, I happen to have a religious belief, religious faith that human life is sacred. Okay, so I act on that belief in a lot of different ways. And so the fact that I might make a decision as a judge based on that concept, I don't think there's anything wrong with that. I think that it's okay too for secular humanists to say that they have the same belief and they can bring that belief to their decision making. So again, I think people confuse individuals bringing their deepest held beliefs and premises, whether religious or secular, to their decision making, to the issue of separation of church and state, which is about practice, which is about practical things, not about beliefs and decision making.
So I think that it's fair to be concerned just in general, not just in that case, but are judges basing their decision on law as it's written, or are they basing it on other sort of preferences or beliefs that they may have, religious or otherwise? Here is an outcome in that case in Roe versus Wade that I think would be more susceptible to the criticism that the judiciary was engaged in what some would call judicial activism, maybe based on their own beliefs. The legal constitutional provision that is being debated in Roe v. Wade is the 14th Amendment, which says no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. And here's the key part. Nor shall any state deprive any person of life, liberty, or property without due process of law. And the debate in that case was whether liberty includes the right to abortion. But what some scholars also argued in that case, some amicus briefs were arguing on the other side, is that, hey court, not only should you overrule your previous bad precedent that says liberty includes the right to abortion, you should also rule that in the 14th Amendment, the word person includes an unborn child. You should say that, which would make abortion illegal in this country, and it would constitutionalize that. And the Supreme Court did not do that. I think that would have been a decision that was even more susceptible to the type of worry about the court imposing their views on the whole country. The Supreme Court just said, look, the Constitution doesn't address this right. They didn't rule on what person means, and they said liberty doesn't clearly enough include abortion within it for the court to get involved. And so they're giving that question back to the people so that the people can decide that controversial but important decision through the political process, like most of Europe has done. In fact, there are feminist professors who have talked about how in Europe it's just not really controversial anymore because they've sort of aired this issue through the political process and they didn't have it frozen in time by the Supreme Court deciding it for them.
Not that I have much to add, that's well stated, but it's sometimes emotions run high and on some of these issues, and that's because they get at, in some cases, very deeply held religious beliefs. They stem from that. But there's a distinction in, we're looking at a political issue, we're looking at a legislative issue, and we approach that sometimes as individuals we view that through our religious lens. But I think that when you're looking at a judicial decision, particularly the Supreme Court, great care is taken to make sure that we're parsing through an actual legal argument and not letting a religious lens cover that issue. That's not well stated. We're not looking at it through a religious lens, we're looking at it through a legal lens.
This to be a more straightforward question. For a member of the Santa Fe Church, if someone drives under the influence of the drug, are they immune from prosecution under the DUI laws? If they cause an auto accident?
No, absolutely not. There's certainly a compelling governmental interest in preventing intoxicated people from operating vehicles. So don't try that at home.
It's the public service announcement for the evening. How do you feel the notice of alternatives was supported during COVID? While there were religious exemptions, they did not seem to apply universally.
Whose question was that? I don't understand the last part. What do you mean about religious exemptions not applying universally? Good question, by the way.
Yeah, thank you. The notion of religious exemption, right? So strongly held religious beliefs.
For mandatory vaccination.
I'm sorry?
Right, for mandatory vaccination? That's what you meant?
Correct.
Or are you talking about, like, the meeting house?
Not just vaccination. It was just, and again, I didn't mean to bring up a hot button, top of your butt.
Oh, come on, that's what we're doing tonight.
Strongly held religious beliefs I saw as the only get around during COVID. It was sort of, rushed to market. It was for the greater good. That was the notion, right? It's to protect the public. But it was, talk about emotions running hot. There weren't a lot of options for people to even take the time to kind of really vet it out and think about it. So it wasn't just about vaccination, it was about all of the protocols. I know it's a very broad question, but it's something that's, we have a recency bias attached to it, something that may come up again, and it's sort of just been kind of left languishing, hey, we're through it, let's just let it go. What happens next time? How can we learn from this? How can we be better as a nation to make sure that we're unified, that we're protecting people's religious beliefs, but also making sure that it's applied evenly, as you said, look through the lens of the law rather than through the religious lens. But some of us wanted to in certain instances. It wasn't just about the vaccination.
Sure. Yeah. No, let me talk about this in two different contexts. One where, so like, I'll give some examples of government that was sometimes treating religion in a disfavored, sometimes even a hostile way. But then I'll think about other cases arose where some people were arguing that religious people were getting preferential treatment to non-religious people in the COVID context. So in the first area, governments during COVID, they were obviously trying to early on just figure things out, keep us safe, make decisions quickly. But as time went on, the Supreme Court expressed concern about the fact, eventually some of these cases made their way up to it, the government was doing things like allowing people in Las Vegas to gather together to gamble, but we wouldn't allow people in Las Vegas to be in the same proximity to take the sacrament, right? So like, you can't tell me that the COVID virus travels differently at a casino than it does in a church. Like, I'm sorry, that argument just has a hard time holding up empirically. But there were even some more like nefarious examples. In New York, the Orthodox Jewish community, I think, was being targeted in some contexts where the government basically drew a map, and it was sort of like redlining, and said these particular neighborhoods are going to be ones where we have stricter COVID gathering requirements than other ones. It just so happened that those neighborhoods were ones that were populated much more with the Orthodox Jewish community. And there was a government meeting where a government official held up a picture of an Orthodox Jewish funeral and said, this is the problem we're trying to solve. Turns out that that funeral photo was 4 years old, but no big deal. And I think that was an example where we see sometimes government in times of fear and national emergencies will scapegoat when they don't know, how best to address a problem. And there's a concern that sometimes religious minorities end up being scapegoated. And this was a case where Notre Dame's Religious Liberty Clinic represented Muslim groups and Muslim scholars who were speaking in defense of the Orthodox Jewish community. And they said, look, we remember what it was like to be targeted by New York's government after 9/11 and be scapegoated, and we don't think it's fair for the Orthodox Jewish community to receive that treatment now. There was a fun, someone reported on that case where they talked about a Catholic organization led by a Mormon professor representing Muslim scholars defending Orthodox Jews. God bless America. That's what religious liberty is all about. Now, on the other hand, sort of like the other side of the spectrum, there were some contexts where religious schools were receiving permission to stay open because of their religious exercise of continuing to serve their students and minister to students, and secular private schools were not. And so there was this sort of question of, is that fair if we're giving religious schools that protection and not secular schools? There were some lawsuits that were brought around that time that argued that maybe we should protect those other secular private schools under parental rights. None of that was ultimately decided by the Supreme Court. But for sure, I think it's something to think about. That goes back to the question that I was talking about earlier. Is there a reason sometimes to provide special protections for religion or not? But at the very least, I do think in our country we can agree we shouldn't single out religion for special disfavor.
One of the things I think we really haven't solved yet in all of the COVID issues is what is an essential service. And we made special exemptions for we needed essential services open. And then we tried to treat like things in a like manner. The place I think that really fails is when you're talking about religious worship. And so you're trying to look at, all right, well, a grocery store needs to be open and have a certain amount of freedom of movement because we need to eat. But does going to church look like more like going to the grocery store or more like going to the theater? And I think early on, the judicial consensus was, well, it looks more like going to the theater. We're sitting down, we're in rows, we're quiet, we're next to each other, we're staying in the same place for a defined period of time. And so in terms of potential virus spread, it looks like that. The problem is it's really not, right? Going to the theater, I think, is an optional activity that you can do or not do, and your life goes on. It's not essential. Whereas going to church, if you're religious, is essential. Going to your worship service feels essential. It feels more like going to the grocery store in terms of the need in your life than it does going to the theater. So we have, as the COVID crisis went on, I think courts were less likely to take the argument that, well, as Stephanie said, we can have casinos open, but we can't have churches open. But it's really one of the unsolved questions, and I think it's a little bit of a missed opportunity to not say, in a way that's understood, attending a worship service this is an essential service, and so churches, houses of worship need to be open.
When I was practicing law, we had to wrestle with issues of mandatory vaccination in those who objected, as well as people objecting to wearing masks. There's a presumption that stopping the spread of communicable disease is compelling a governmental interest. Now, of course, a lot depends on the setting, but we represented healthcare institutions that mandated that their staff be vaccinated, and I think that there's a strong argument that the compelling interest in protecting coworkers and patients from the spread of this disease was strong enough to override people's religious objections to getting the vaccine. Now, of course, in retrospect, we have learned that getting the vaccine doesn't prevent you from acquiring the virus, but on the other hand, it does tamp down on the symptoms. And frankly, if you're a healthcare worker and you're doing less coughing and sneezing, you're less likely to spread that disease, and it saves lives. I think that's the state of the evidence today. If the evidence changes, there will be a better argument to allow for religious exemption, but right now I don't think it's there.
Shifting gears, we have a question about the Supreme Court as an institution. Recently, the court has been considering creating a formal code of ethics. Do you think that this would help to strengthen support of the court and reassure Americans that the court is impartial?
Guys are throwing us all the softballs tonight. I mean, the court does already have some pretty strict ethical guidance. I'm not saying that there's not room for more. I don't have a strong opinion on that. I clerked at the Supreme Court, and I know that the justices that I interacted with, or whenever these sorts of things came up, took that pretty seriously. Do I think that it's good in a democracy for government officials to have transparency, to not be able to accept gifts or things like that? Yeah, I think that's important. But I think the devil's in the details of exactly what that sort of, if we have any additional requirements, what those would look like.
One final question, and this has certainly been a multidisciplinary set of questions. We are moving to a more philosophical plane here, I believe. Can religious liberty exist in a culture where people have a diversity of religious beliefs, including totally different premises about human nature?
I mean, the short answer is yes, right? I mean, it's one of the wonderful things I think about seeing each other close up and getting to know and understand each other is making space for each other. It goes back to this idea of accommodation, and can we accommodate those who are very different from us and understand and value the contributions that they have. And I think we're all enriched when we do that. I think that living in a pluralistic society is wonderful and complicated and also life-giving and enriching. And I think that it's not without its challenges, but it's worth doing, and it's worth doing well.
Yes, I agree. I think that's why it makes sense to have an accommodative approach to the wide variety of religious beliefs and practices. in this country, and I think we're stronger and better for it. Of course, at the margins, there may be issues that are so different and diverse that they can't be resolved in a way that accommodates both sets of beliefs. And frankly, the abortion issue is one such issue. And our only choice in that circumstance is to allow the political process to play out. A comment was made that in Europe, abortion is not controversial. That's exactly right. And that's because each country in Europe has addressed the abortion issue through the legislative process. And in some countries, the laws are stricter, and in other countries, they're more liberal, and they reflect the predominant view in that particular country. And yes, within each country, there are individuals and groups who are very unhappy, but apparently they've accepted the resolution because it has gone through that small d democratic process.
I agree with all of that. I think what I would just add is that in a society where people have a wide range of religious views and sometimes don't even agree on the same premises, I think that's an area where it's more important than ever that we have religious freedom protections. That we live in a world where we not only live and let live, but we're willing to speak up on behalf of our neighbor or those with whom we might disagree, but we want to defend their right to live life according to their deepest held convictions. Before being a professor, I used to litigate with the Becket Fund for Religious Liberty, and their motto is that they represent clients from A to Z, from Anglican to Zoroastrian. And I can't tell you how happy they were when they got that Zoroastrian case. Because before that, I did it somewhere else earlier than that, but it was really awkward. And the first time I represented a case, even before working at Becket, where I represented someone who I disagreed deeply with about their religious beliefs, it was a prisoner who was an adherent of what he described as an ancient African religion called Shatat Natur, and he was seeking a dietary accommodation. And the first time we spoke on the phone, I was just a new baby lawyer working for a law firm in DC and had been assigned his case pro bono. And he was explaining his religious beliefs to me, and he said, look, I doubt you're a member of Shatat Natur, so I'm sure my religious beliefs don't matter that much to you. And I told him, actually, I mean, you're right that you and I have different religious beliefs, but your ability to practice your religion and as much as possible matters a great deal to me. And that's why I'm working on this case. And it was just one of those moments where I really felt the truth of what I was saying to him. And I have seen my students at Notre Dame get to have a similar experience as they've defended Muslims or Native Americans or Orthodox Jews. And they don't agree with the beliefs, but there's something beautiful about learning about someone else's beliefs and not just tolerating them, like plugging your nose and being like, okay, I guess I can live with this, but like, I want to help you. I want to live in a society where you can flourish and I can flourish, and it is not a zero-sum game. And I think that is a society worth fighting for.
I think that's a wonderful note to end on. Allow me to bring up Dr. Ray Hebert to conclude this properly.
Thank you very much. I thought I would close by telling you a little bit about what we're planning in 2024. We're going to do something a little different. We've had some questions over the last several years of running the IRL about the different religions that we work with and how some of those who have attended asked to know more about them, to learn more about them. Now that coincided with the recent move to this area of an international expert on interfaith dialogue that I want to introduce to you, Dr. Brian Adams. Brian was the executive director of a Center for Interfaith Dialogue at the University of Queensland in Australia for 12 years, who did some remarkable programs, and he and I had been in touch talking about those, both local for them and then international. But he will moderate 2 sessions for us on interfaith dialogue. that will be entitled, "Who is My God?" And the idea, and I'm going to quote from Brian's proposal to me about this, we're going to do two of them. One in the spring on February 21, by the way, Wednesday night, and then one in the fall in our new building. And we look forward to holding it there. But here's the point that it makes. The idea is to bring together people of different religious and philosophical traditions in a moderated dialogue format to present their understanding of the dialogue theme, "Who is my God?" Their responses can be from any perspective, such as theological, philosophical, doctrinal, personal, practical. Having a range of presentation styles will obviously enrich the richness of the evening, and we will allow each of the panelists to take it in whichever direction they wish to take it. The idea being, after each gets a chance to speak 10, 15 minutes, then they'll have a chance to maybe respond to each other, and then we'll open it up to the audience. The idea is to enlighten all of us in terms of different views about not only who is my God, but perhaps about things like immortality or death or traditions or such. So again, February 21 will be the first one. Two of our panelists are here tonight. One is Shakila Ahmad, who is with the Muslim Center of Greater Cincinnati in Westchester. And the other is Dr. Gary Zola, who was the rabbi and executive director of the Jewish American Archives at Hebrew Union College. So, and then we'll have probably a total of 5 religions that will be represented. And then in the spring, in the fall, depending on how the one in the spring goes, then we'll adapt the one in the fall. But they will be moderated by Dr. Adams, and we hope you'll join us then, and you'll tell your friends about what it is that we hope to do with this concept of interfaith dialogue. And with that, I ask you to join me in thanking our speakers.